Justice Kagan?
Ms. Blatt, you said in response to Justice Barrett's 1604, 1605 argument that you were leaning quite heavily on 1330. But I'm wondering whether 1330 makes your position even stranger. I mean, you're positing a statute that starts at 1330 with the jurisdictional provision, clearly only looking to civil cases, then switches to civil and criminal on the main immunity provision, and then switches back when you get to exceptions to immunity to only civil cases. And I would think that you look at those three sections and you think they should all work together. They're all governing the same universe of claims, and that suggests that 1604 is doing only civil, just as 1330 clearly is, and as you say, 1605 is.
Yeah, and so just 2 points. And I think, again, the backdrop of all of this is that the FSIA was trying to codify international practice and law. And international law, I don't think the government can dispute this, is there's been absolute criminal immunity. So Congress had no reason to do anything at all about procedures or anything else when it came to criminal cases, because there's no such thing. So Congress passed a very broad immunity statute, and then everything else it has to say about the subject is civil, because those are the only kind of cases that could go forward. So yeah, I see how, the you did, but if you just look at it from what Congress had in front of it, there was no such thing. The government has 2 subpoena cases, and that's it. There's never been a criminal prosecution of a sovereign or its instrumentality here anywhere. And so just Congress, otherwise, one would think that if Congress knew that it was even possible, they might have allowed removal. They might have done things like been respectful on service and said maybe you should send it to the embassy instead of FedEx. They presumably would have said something.
Well, maybe Congress thought, would they have said something if they thought that there was common law immunity so that a statute didn't have to get involved? Then they wouldn't have passed a statute with any involvement of criminal actions.
Oh, no, Justice Kagan. We know, you've said this so many times, that the FSIA was to clear all this immunity up once and for all because it was a disaster.
Well, but what was a disaster was a lot of civil actions. As you say, the criminal actions were never brought.
And they would have done something about juries. I mean, I just think, again, the one thing, just to not have any protections or any procedure seems to me quite odd when Congress thought so comprehensively about even the notion of sovereign immunity. And so to us, it seems odd that Congress, I think it's attributing that Congress is just, I not like the word indifferent, but would let the Justice Department, or the President, rather, the President, control how these things happen. There would be juries, there would be fraud claims, there'd be no removal if states can. I mean, I think the government's view is that states could prosecute, and you'll have to figure out how it's preempted under, I don't know what law I'm sure you'll ask them about preemption, but I don't even know how they would muddle through how this would work out in state court under common law immunity.
Okay, thank you.
Justice Gorsuch?